In Maharashtra, anyone associated with any organization of dissent can be a public security threat now. As vague as it sounds, there is an actual law at the governor's table likely to become a new law. The Maharashtra Special Public Security Act 2024 was passed on 10th of July by a majority of votes in the Maharashtra State Assembly. The bill says that the unlawful activities of the organizations need to be controlled by effective legal means. The existing laws are ineffective and inadequate to tackle the threat of Naxalism. The bill was first introduced in July 2024. It was not passed at that time, so it was reintroduced on December 18, 2024 after BJP leader Devendra Fadnavis assumed his office as Chief Minister. When the bill was being considered in the Assembly, Mahavikas Aghadi, left parties and democratic organizations, civil society groups, they protested against the bill at Mumbai Azad Maidan on June 30th. Congress MLA Nana Patole pointed out that despite 12,500 suggestions and objections submitted by the citizens to the proposed legislation, the state government accepted only 3 and made minor amendments ignoring the public opinion. This new bill was then passed by Vidhan Sabha on 10th of July and the Vidhan Parishad on 11th of July. The act now awaits the governor's approval. The government claims that the new bill is necessary for public security, but similar laws are already in place. This act clearly overlaps with the widely ranged Unlawful Activities Prevention Act of 1967, UAPA, Section 113 of Bharatiya Nyaya Sanhita BNS, and closely resembles provisions of the Maharashtra Control of Organized Crimes Act, MCOCA, a severe state-level law. These laws serve similar function and powers to criminalize acts of terrorism and threats to public order. But what exactly is this Maharashtra Special Public Security Act? And why is it raising so many concerns?
So what is the Maharashtra Special Public Security Act? Ostensibly, the government has brought in this act to curb Naxalism. Now, the challenge is that if the government claims it has been successful in curbing Naxalism and reducing it to only 2 districts in the state, then why is this act necessary as the Naxalite movement is at its weakest in the state and across the country? Second, the government says that it's to prevent the infiltration of urban Naxals and Naxalite ideology in urban centers of the country. Now, the problem with such a broad definition of Naxalite ideology and urban Naxals is that under this government's definition, everybody is an urban Naxal. You're an urban Naxal, I'm an urban Naxal, everyone in the opposition is an urban Naxal, anyone who stands up for Father Stan Swami, who was denied a sipper in prison, is an urban Naxal, whoever speaks up for GN Sai Baba is an urban Naxal, whoever joins the Bharat Jodo Yatra, according to this government and according to Devendra Fadnavis ji, is an urban Naxal, and according to the Shiv Sena, which is the alliance partner, there are Varkaris who are urban Naxals, because the Varkari movement, one of the oldest traditions in Maharashtra, which is progressive and in many ways secular, is urban Naxal. So when you have an act whose stated objective is to destroy something that can be classified as anything, then that's where the act becomes dangerous. This is the opposition that has been raised both in the Vidhan Sabha and the Vidhan Bhavan, and then after as well by several prominent leaders, including from my own party like Rohit Pawar, who gave an incredibly important speech, saying that if you want to curb Naxalism, then why is the wording in the act left-wing extremism? What is left-wing extremism? Why has it not been defined in an act? There's a very big difference between niyat and niti. अगर नियत खराब हो तो हर नीति को का दुरुपयोग किया जा सकता है. But in this circumstance, both the niyat and the niti are kharab. The law as it stands today is so vaguely worded, so ill-defined, that it can be used to target any single citizen or collective.
Now, according to the statement of objects and reasons of the bill, the government claims that the extremist groups are using frontal organizations in urban cities and are creating tensions among common masses to propagate their ideology of armed rebellion against the constitutional mandate and disrupting public order in the state. The Maharashtra Special Public Security Act 2024 is designed to give state more legal power to ban organizations and penalize individuals whom the government is suspicious of being involved in or supporting Naxal and Maoist activities, especially in urban areas. The state government can declare any organization unlawful through a notification in the official gazette on mere intuition. This declaration is then to be reviewed by an advisory board consisting 3 persons who are or have been or qualified to be appointed as the judge of the High Court. Members of this advisory board will also be appointed by the state. If the advisory board confirms the declaration, the ban can be extended. If not, it must be withdrawn. Now, there are concerns by civil society groups that the advisory board under the law would not act independently if they were to be appointed by the government. The law allows the government to seize properties, evict people, and take over any place believed to be used by the unlawful organizations. All of this can be done through official notifications and without needing court trials in many cases. Entering any building or area that has been officially declared as a notified place under this act without prior permission from the district magistrate or commissioner or police or any authorized officer would be considered a criminal offense. This means that even unknowingly entering such a place without approval can lead to criminal charges under this act. This new SPS Act makes all offences cognizable and non-bailable. That means police authorities can act on their own, arrest without warrants, and investigations can begin only after written approval from a high-rank officer. Any member, supporter, or promoter of a banned group could face up to 7 years of imprisonment and fines up to 5 lakh, depending on their role. The Act identifies 4 broad categories of punishable offences. Being a member of an unlawful organization, participating in its activities, or financially supporting it is an offence. Even if not a member, providing financial aid or sheltering a member of an unlawful organization is punishable. Managing, promoting, meeting, or otherwise engaging in the unlawful activities of such an organization through any means is prohibited. Committing, attempting, planning, or helping to commit any unlawful activity linked to such an organization is illegal. The Act gives district collectors and police excessive powers to deal with the properties of the organizations targeted by this law. The law even grants government officials, police authorities immunity from any civil or criminal proceedings as the actions were taken in good faith under its provisions. It does not end there. Further, government will have full authority to frame rules and expand this law further through any gazette notifications. Given Maharashtra's history of misusing laws like UAPA in the Bhima-Koregaon case, it raises serious concerns that the excessive power given to the authority under this law could lead to further abuse and targeting. In the 2018 Bhima-Koregaon case, the authorities overlooked the actual cause of the violence and arrested lawyers, activists, and academicians who were known for speaking up for the rights of Adivasis, Dalits, and marginalized groups. They were called urban Naxals and charged under strict anti-terror laws, making it clear that the case was more about silencing dissent than fighting extremism. Chief Minister Devendra Fadnavis, while introducing the bill, defended it strongly. He pointed towards the increasing influence of Naxal activities in urban areas and said this new law would help Maharashtra control Maoism more effectively. But the law is filled with vague terminology, giving the government wide powers without clear definitions or safeguards. There is no clear standard for declaring an organization unlawful, and protesters or writers critical of the government could easily be targeted. Congress MP Varsha Eknath Gaikwad called the bill's language extremely vague and warned that it could be used to label peaceful protest as illegal. Terms like contributes, receives, solicits, promotes, unlawful activity, unlawful organizations, these are all vaguely defined. Activists, students, journalists, tribals, and protesters could all fall under the risk of being branded as threats without clear evidence or due process. CM Devendra Fadnavis had previously in December 2024 said that those participating in the Bharat Jodo Yatra are urban Naxals. So who exactly are urban Naxals in the eyes of government is ambiguous. Civil society groups and social organizations have opposed the law ever since the draft bill was first tabled in the assembly last year. These groups argue that although the state claims the bill is aimed at curbing urban Naxals, the preamble is open-ended and does not specify urban Naxals and unlawful activities. This empowers the government to take actions against any individual they want to silence. NCP's Anish Gawande called it a law meant to silence, not secure. He says that now anyone can be branded as an urban Naxal. If you protest loudly, you're a threat. If you write too freely, you're a conspirator. And that this bill is a part of BJP's Shut Up India campaign.
I said the Maharashtra Special Public Security Act is designed for misuse. You know, the act has no real intent. It has no noble intent. When a law like UAPA exists, when provisions like sedition still exist in the BNS, you don't need something like the Maharashtra Special Public Security Act to tackle what you're saying this law will tackle. More importantly, we have to recognize that we live in a very different India today. The safeguards that existed under UAP, including things like sanction to prosecute needing to be granted by a wide set of authorities, don't exist in the Maharashtra Special Public Security Act or exist in forms that are easily manipulatable. Now, if you don't have any independent scrutiny of any sanction to prosecute under the Maharashtra Special Public Security Act, if it's only going to be police officers who you can apply pressure to, like you applied pressure to in the Pune Porsche case, in the Vaishnavi Hagavne case, in the Beed Sarpanch murder case, then what faith can both the opposition and civil society organizations have in your ability to use this law towards its stated intents? So other laws exist already which allow you to do what you say you're trying to do with this law. This law has very vague definitions that make it a tool to be misused rather than something that can be misused. And finally, the safeguards that should have been put in a law like this, despite amendments that were made through vociferous voices from the opposition, remain inadequate to ensure that its misuse will not be countered. Because the process in India is the punishment. We've seen this with the ED, we've seen this with the CBI, we've seen this with police officers. You know, time and again, cases are filed, the petitions move through the courts, but some people, like YouTubers who we've also stood up to defend, can get Supreme Court hearings in one day. But the rest of this country can take months, if not years, to find justice in the corridors of our courtrooms, in the Supreme Court and the High Courts. So in such a situation, the act is simply untenable and seems to be designed to curb a growing set of opposition voices that have threatened the Mahayuti government in Maharashtra.
Addressing a press conference, Sanjay Raut said, "This so-called Jan Suraksha bill is nothing but a BJP Suraksha bill. The BJP is scared not of Naxals but of NGOs, social groups and opposition parties who raise their voice. This law is made to target those who protest, especially tribals fighting for their land. Adivasi communities, who have historically been among the most affected by state neglect and the presence of Maoist groups, now face increased risk under this act. With its vague definitions and sweeping powers, the law could make it easier for authorities to label ordinary Adivasi villagers as sympathizers or supporters of unlawful organizations, simply for living in or near the areas of conflict. In a state where asserting land rights or resisting displacement is already seen as extremist, this law could further criminalize disputes or deepen the marginalization of these vulnerable communities. While the Maharashtra government says this law is about ensuring security, many fear it could become a tool to suppress and curb democratic rights, all under the label of public order. It potentially undermines fundamental rights including freedom of speech, association and protest guaranteed under the Constitution. Its more than necessary powers, limited judicial oversight and minimal space to oppose raise alarms about the misuse. This law challenges the Constitution, and that is a pressing concern.